So please welcome you up, Susan May, please. Thank you.
Thank you. Likewise, I've got a very bad cold, so excuse my voice, but it's always good to be here with you all, and thank you for inviting me along. 20 years ago to this very date, the 30th of March 1992, my home was being raided by numerous police, and I was carted off to Oldham Police Station, accused of something I did not do. It was the beginning of the worst nightmare ever, which still continues. A number of you will be familiar with my situation. I was wrongly convicted of murder 20 years ago, and despite fighting from day one to prove my innocence, I still remain convicted. My auntie was 89 years old. I saw her on the night of the 11th of March 1992. She waved me off as I left her, and I discovered her body the following morning. You have, I think, a brief history on my case. I've had 2 appeals. I believe I was wrongly convicted because I had a poor defence team for trial. I totally trusted my then solicitor. He was my local family solicitor. He'd never handled a murder case before, and I even trusted the police at that time. I was brought up to do so, very foolishly. I feel it's important that you shouldn't be given just any solicitor. I think it should be a legal procedure that you are represented by a solicitor who is au fait with the law that you are being convicted of, accused of. He should have told me that he wasn't familiar with criminal law, and he should have handed me over to a criminal solicitor. I feel stupid now to say he told me I didn't need any defence expert witnesses. To challenge the prosecution, he said I wouldn't get convicted, and I believed him. I was innocent, and I was absolutely grieved to the world of injustice. So I went to trial with only prosecution evidence. And another huge problem, I feel, is that in many cases, expert witnesses, especially prosecution expert witnesses, go way beyond their remit and expertise, and juries are influenced by this. Obviously, my QC could cross-examine what was being said, but that isn't as powerful as having defence experts there to give different opinions. But the jury should be allowed to hear differing views, to give them the opportunity to realise there are 2 sides to the story being told. My jury didn't know there were other suspects, unidentified fingerprints, footmarks in the house. My jury looked at me in the dock and they must have thought, well, it's not her, who else? No other option was offered to them. And sadly too, once convicted, if your defence didn't run with all the evidence available at trial, then the Court of Appeal will say it's not new evidence. And there, it was available pre-trial, it can't be used as an appeal. For anyone given a life sentence for a crime they're totally innocent of is the most horrendous thing ever, and the road ahead will always be difficult. Once convicted, to overturn the verdict made by the jury is fraught with red tape, bureaucracy, and attempting to show this wonderful British system was wrong becomes a challenge of all challenges. It's as though the system has to be protected at all costs. The CCRC was formed 15 years ago, and I thought it was a beacon of light which would ensure those wrongly convicted got justice. 15 years ago, I was in Durham prison where I spent 7 years. I'd just lost my first appeal, and hearing the news of this new and independent body was to look into alleged miscarriages of justice filled me with so much hope. My first appeal was 1997. It failed and I was in despair. My lawyers informed me there were no grounds to appeal the judgment. Only if new evidence came to light could we make a submission to the CCRC. Effectively, it was the end of the road. Nevertheless, I proceeded to make and submit my own submissions to the CCRC, who then carried out a thorough investigation of the whole case. They identified new evidence and referred me to the Court of Appeal. Today, lawyers can claim a specific fee for reviewing a case for submission. The CCRC advises prospective claimants of this and provides a list of lawyers, solicitors prepared to undertake this work, and a set fee is covered only in just a few hours' work. It seems to me that the CCRC now sees its role as a tester of these submissions, and this was not what the CCRC was set up to do. When I sent my case to the CCRC in 1997, I had renewed hope that at last a fairer system was in place following the major miscarriages of justice, the Birmingham 6, the Guildfords and Maguires, as we've heard before, and other notable cases. I was appointed an excellent caseworker, Dawn Butler, who really got her teeth into my case. She uncovered lots of new information. She discovered that the Chief Prosecution Forensic Scientist had rewritten his original notes from 1992. So after I was convicted and in preparation for future appeal, he forged a new document. She proved the senior police officer in my case had lied. She found out that he'd also had the main forensic exhibits removed from Forensic Science Laboratory months before my trial, stored them in a locker at Oldham Police Station, something he denied in later years, saying that had never happened and that the wall had only been photographed, the exhibits had never been removed. But only when we pushed the CPS and the DPP did he finally admit that these forensic samples had been in his possession for over 3 years, in unsealed bags. Yet he has never been brought to account for this. Various courts have just said it was unfortunate that he didn't admit to having had these samples. It became a catalogue of errors and lies, and on the strength of Dawn Butler's findings, I was referred back to the Court of Appeal in 1999. Sadly, my appeal hearing was delayed because my QC was doing the Jill Dando case, and my appeal didn't get heard until 2001. And I say sadly because I truly believe in the first few years the CCRC weren't doing the job expected of them. In turn, the Court of Appeal was showing respect for the Commission. But after around 2000, there appeared to be a turning point. It was as though someone in the realms of power was saying that too many mistakes were being shown, that the system was being shown to be too wrong. And then the Court of Appeal's criticism of the CCRC seemed to become greater. And in my view, it became as though the CCRC were a little scared of the Court of Appeal and their remit for sending cases back changed in order to appease the Court of Appeal. When the CCRC was founded, we lost valuable people who before had investigated wrongful convictions, trial and error of justice, panorama, all had brilliant people working for them, investigative journalists who had a passion for righting the wrong, who would go to any length to look into a case. Inevitably, they all thought the CCRC was now going to take over that work, investigating thoroughly. Sadly, it doesn't seem to be the case. It would be great now if the Commission would look back at the reasons they were set up in the first place, and how cases were unlocked by good investigative journalists and those who were willing to knock on doors and uncover the truth. Obviously, the CCRC would need more resources and not less to do that. However, my appeal went ahead and the statement of reasons issued by the CCRC were powerful. Just on the point of the forged evidence, I should have walked, but I didn't. That appeal was dismissed. Yet again, I hit rock bottom, but as always, pick myself up. And because of the record, I've been told the CCRC themselves were disgusted with the actual judgment from the Court of Appeal, I reapplied. I said that because they were independent and if they disagreed with the Court of Appeal, they should be bold and they should stand up and be counted. They did take my case back and they even gave me Dawn as my caseworker again. She said my case was to be prioritised. It would take approximately 6 months, I was told. That was 2002. Dawn told me she was set out to totally discredit the senior officer in my case. She was compiling a dossier on all the inconsistencies and lies that she'd uncovered. Very sadly, Dawn died, and my case was passed to another caseworker. And the promised 6 months went on to 8 years. And I got a negative decision recently, well, in 2010, that my case wasn't to be sent back to the Court of Appeal. They sent me back in 1999 on strong evidence, which still stands. Today, we now have even more, even on recent CCRC findings, so it seems unbelievable that they refused me. The Chief Prosecution Scientist in my case has been discredited. His evidence has been struck out. The evidence of his assistant has been deemed by the CCRC as unreliable. The senior police officer in my case, whose evidence the Court of Appeal relied on to dismiss my last appeal, has been described now by the CCRC as no longer impressive, reliable, and that his evidence could no longer be relied on. There are many conflicting statements on the forensic issue, total confusion around the prosecution's statements, statements written retrospectively should not be allowed, just fitted around the person that they're trying to convict. So what more does the CCRC want? And another point I think really important is Dawn came to see me several times in prison. I even met the commissioner who was overseeing my case, Sir Lennon Lane. And this is something they should do. Meet with the applicant face to face, which doesn't happen now. Maybe due to cost cutting, but what price is justice? However, not to be deterred, I've continued to push the Commission again and again. And my last QC, Michael Mansfield, recently wrote to the Commission saying he couldn't believe that they refused to send my case back. So recently they've allowed me to reapply. So I have done, and I now wait to see if they accept my case again. As you see, I'm not going to go away, and I will fight for as long as it takes. As many have spoken already this morning, you know, they're saying the CCRC have lost their way, that they're not fit for purpose, and I'm not saying this through sour grapes. My case doesn't stand alone. There's Eddie Guilfoyle, Jeremy Bamber, Woolley Beck, Andrew Poundley, Carl Watson, Neil Hurley, Frank Wilkinson, Simon Hall, Ray Gilbert, and many others, as the dossier in front of you shows. We have to at least have a review of the only way we've got back to the Court of Appeal through the CCRC. In the past, the Police Complaints Authority was replaced by the IPCC because it was seen to be failing, and critics will even say now that the IPCC needs re-examining. Any body like these has to be subject to scrutiny. We need a full reappraisal of what the CCRC began as and how it is now. They're not only second-guessing how the Court of Appeal will view a case, but how the Court of Appeal viewed it previously. This should not be their priority. The whole case needs to be considered, even if fresh evidence is being identified. They must look at the full picture because everything is relevant. The real possibility test is definitely important to the CCRC. The Scottish CCRC has more powers than our Commission. At various hearings in my case, the trial and 2 appeals, only fragments of my case were heard because of the rules surrounding appeals. Plus, when time passes and you discover more about a certain point that may have been argued before, because that point has been referred to at a previous appeal, you are told it can't be raised again. That's madness. It's totally unfair to have to base an appeal around completely new evidence. The whole picture needs putting forward in order to show how newly discovered material can completely alter what a judge ruled on previously. Fragmented evidence is biased and very unhelpful. My case is now totally different to that my jury heard in 1993. People like me do not bang on year after year about their cases for the benefit of their health. In fact, it's detrimental to one's health. The desperation of injustice is painful. It's all-consuming, and it never goes away. And another great concern is the attitude of the Court of Appeal. Even if the Commission refer a case, there is no guarantee that the judges will acknowledge the evidence the Commission has found. Following my last appeal, an article was written about the failed appeal. The journalist in question had sat through the whole appeal, and he literally said, were the judges in the same court as him? And he titled the article, Who Judges the Judges? And that's so true. And maybe now we have to ask, who judges the CCRC? It's our only way back to the Court of Appeal. And yet in the last 6 years it hasn't really achieved very much. I know Chris Mullen disputes some of the facts, but some of those that they would claim sentences overturned include dogs with muzzles, without muzzles and things like that. It was supposed to be set up to deal with major cases. But out of those major cases referred in the last 6 years, only a very few have been rectified out of hundreds of applicants. Mistakes happen. Lawyers make them, juries and police. And it leads to innocent people being convicted and going to jail for many years. And it's a never-ending nightmare. I was fortunate to be released after 12 years because throughout my time in jail I was classed as an IDOM, in denial of murder. I refused to take part in any obligatory offending course, prison offending behaviour courses. I've used homilies, etc. Anything that allowed them to say I was proving that I was safe to be in the community, I refused. So I was told I'd never be released because I refused to conform. But even though I may be free from the confines of jail, I'm not free. I still feel locked up because my conviction still stands. I'd hoped I wouldn't be institutionalised, but I was. My family see me as a different person now, because I am. It took me ages to readjust to life outside, and in fact I still have hang-ups. I, along with all others who've been through this, are damaged. Prison damages you. And the whole experience of being wrongly convicted and the years spent in jail leave scars that never disappear. Families are damaged. My fight goes on, and I'm sure this contributes to my determination to stay strong. I was determined to survive the horrors of prison whilst inside, and I still have that determination now to fight this system which locks up innocent people and refuses sometimes to admit that. As far as I'm concerned, the work that the Innocent Projects do, and others studying law, is proof that the whole system is flawed. I can't stress enough how valuable and useful the work is that they do. If the system was working correctly, there would be no need for your involvement. You would just be studying the different aspects of law. But believe me, you are needed and appreciated.